Good afternoon. We're on the record in the matter of Horodesky versus Johnson, case 06D349743. I see everybody here. Good afternoon, everybody. Mr. Carmen.
Michael Carmen, bar number 7639 for Chris Horodesky, who is present by video, Your Honor.
Good afternoon, Your Honor. Amber Robinson, bar number 10731, on behalf of defendant Amber Parker, who is present.
Okay, welcome everybody. We're here for a status check, return from FMC child interview. Did everybody have an opportunity to review the child interview?
We talked about the child interview last time. Your Honor asked me to file a brief on the jurisdictional issue, whether the court has jurisdiction to review Judge Forsberg's order.
Yes.
We did file that brief, and
Yes.
and again, we have another response filed without attorney's signature on it by a represented litigant before this court. I understand you're allowing it, but I have some real issues with the representations being made. Ms. Robinson knows that the delay on the order. I don't like to call out other attorneys, but the reality is the order was sent to Ms. Robinson as early as November. No response was received. We submitted the order to the court in December, and the court didn't sign it for a month. This idea that we deliberately delayed the entry of the order, it's just not accurate. And in fact, blame needs to be accepted all around because I couldn't get a response from Ms. Robinson.
So
if you'll look at the file, the order...
You're talking about the order from Judge Forsberg's decision on July 16, 2020?
Correct.
Okay.
The representation made by the litigant in this case is that we deliberately delayed the entry of that order. It's just not true. It took a while to prepare, but it waited over a month in Ms. Robinson's email box with no response. We had to submit it to the court without opposing counsel's signature, and the court took a while to enter it. If her counsel had cooperated and signed on, it would have been entered. And I get it. She's in pro per. Maybe she doesn't know all the details, but she continues to file pleadings with this court that are recklessly false.
And you're talking about, are you talking about her defendant's reply to plaintiff's brief regarding the jurisdictional authority that she filed on July 19, 2021?
Correct, as well as the prior pleadings filed with this court that I've asked to have stricken.
We've addressed this before, Mr. Carmen. She claims, I tell you what, I'll just try to satisfy you again, but I know it won't. Let's swear the parties in again.
Raise your right hands, please. You and each of you do solemnly...
Mr. Horodesky, raise your right hand.
You and each of you do solemnly swear the testimony you are about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Horodesky, I think your mic is turned off.
I do.
Okay, thank you. And you can turn your mic back off again. So, Ms. Johnson, who wrote this reply to plaintiff's brief regarding jurisdictional authority?
I did, and I uploaded it the other evening.
You wrote it. You obtained all of the legal, the case, the Rolfing case, and all of that?
Yeah, I Googled it, and you can read it and hear all about it. And I agree a lot with the case. I find some of the facts very interesting. I just don't see how it's necessarily applicable in this case, given the circumstances.
Okay.
Which was in my reply.
Okay. So, Mr. Carmen, I don't know what else I can do. She has the right to have unbundled counsel appear at these hearings. And this is at least the second time that I've put her under oath and asked her who wrote these documents that she filed. And under oath, she says that it's her. So I don't.
I think Your Honor is I understand that aspect of it, but she continues to put false representations in pleadings. There have to be consequences to that.
What do you mean? What did she say that's false?
He's claiming that we deliberately delayed the entry of the order, and so that it essentially caused it to be signed during the reassignment by the judge.
I see.
It's just not accurate, and her own attorney has to take responsibility for her part in that delay.
Okay, well, I'm not making any findings about that, Mr. Carmen, so that argument carries no weight with me. It is what it is. It happened. The blame doesn't get us anywhere, so we move on. So let's talk about your briefs, the substance of your briefs. I have read both of them, and Mr. Carmen cites to a case Rolfing v. District Court, 106 Nev 902 in 1990. It's a Nevada Supreme Court case. Mr. Carmen indicates that the Nevada Supreme Court held that under the Nevada Constitution and NRS 3.220, district judges lack jurisdiction to review acts of other district judges, of other district courts. So and Rolfing specifically involved the reassignment of a case to a different judge within the same judicial district after a judicial reassignment, and the Nevada Supreme Court specifically determined that the successor court acted beyond its jurisdiction in vacating the orders of a prior judge. And then in review of Ms. Johnson's reply regarding the jurisdictional authority, she discussed a little bit about the Rolfing case as well. I've found some language on page 4 stating that, and I agree with this analysis. It says it must be noted that there were unique circumstances to the Rolfing case where it was not unusual for a criminal case to be assigned multiple departments and one case being heard on a rotating calendar in multiple departments with multiple judges. Simply put, this referenced case clarified that it is improper for one of the judges involved to essentially void another judge's order, especially when a judge disagreed with the prior order, and that following proper protocol was required when challenging prior orders, etc. The Rolfing case also was in the trial phase, where this case never advanced to a trial phase and stayed in status hearing phase. The Rolfing case does not mirror the issue now before the court. It did not involve an administrative court reassignment, as happened in this case on January 4th, 2021, where this was an actual court reassignment. And although I didn't understand a little bit of her logic in some of the statements that she made, but again on page 9, though, this is not a case of a judge simply wanting to cancel out another judge's order, such as in the Rolfing case. Per the point and authorities above, the defendant clearly believes that this currently assigned department and judge have the jurisdiction to resolve this current motion at hand. And I must say, I do agree. This case was reassigned to me, and this case is not the only case where it comes up where this court has to sit and review and reconsider the findings and orders of a prior judge. I mean, it's very common, I have learned, that many cases they do file motions for reconsideration of the previously assigned judge, and it is necessary for me to sit and try to review those cases, and I do so by reading the record.
Can I comment on your findings, Your Honor? The one thing that is, it's just a misstatement by Miss, well, not Miss Robinson, by Mom, is that Rolfing did involve, it absolutely did involve a motion for post-trial relief. It was not in the middle of the trial phase. It was a motion to vacate the ruling of the prior judge. And the Supreme Court was clear. There's just no jurisdiction. A court can't review a fellow judge's opinion. I disagree with her. It's an administrative reassignment, just as this case was administratively reassigned to your department. If it had been a Department G case and you had come in Department G, it may be a very different scenario. But this is the scenario that we're in this case is the identical scenario in Rolfing. There was an administrative reassignment to a different judge. That is the case. I think that at least I would read the case, because she is misstating the posture of the case, she's misstating the holding of the case, and she is misstating what exactly occurred in the case.
Let me check something else out. But you got to give me just a minute here. So let's go off the record. I don't want you to have to sit here in all this dead air space. So let me just go off the record. I'll be right back.